Okay, thank you for joining me for a premiere video. This is our first time actually going live at academia and industry, and so for those that kind of started with my origins, I appreciate you guys being here for the progress that I'm making and sticking with me, trusting me to teach you about different topics of academia, different areas and trades of expertise, and my personal interest, human resources. So, we've got a course this semester that I'm taking that is vital to human resource management, labor relations, anything dealing with personnel management. So I'm taking employment law. This is the foundation, and I put together a basic outline of the course. The first 3 chapters I'm going to cover, and I'm going to talk about the textbook, the recommended reading, and just how this course transfers. So that's the first step. So this is actually a little bit of a story. We'll go back. This is a course that I found by happenstance. I was looking for a course that gives credit for certification, also counts with your associates, also counts with the bachelor's program. I'm a Penn State student, HR, labor relations, and I found this course transfers across all 3. It's rare that you find community college level courses that you can pay community college level prices and also take them and have them count at a university. So I deviated a slight bit from my typical community college that I grab my classes from when I want to fill stuff in, and I went to a new school. So I will go over the course. All right. So the first is employment relationship. I'm just going to go through and give you a brief lecture. The chapter checklist. We're going to define employment relationship, distinguish between an employee and an independent contractor, understand the duties of the employer and the worker, know the parameters of a covenant not to compete, and when it is enforceable. We're going to discern when an employee's actions occur within the scope of employment, and we're going to cover employment. Employment is defined as rendering of personnel service by one person on behalf of another in return for compensation. So these are just basic vocab terms. You're going to see them throughout the chapter, and just to have a familiarity with their reference. I think they're fairly self-explanatory, but I will cover them just so that is stated in our video here. The next term is principal. Employer who employs an agent employee to act on their behalf and has full control over the employee. Okay, so this is a little bit different than an independent contractor, because the employer doesn't have full control over an independent contractor. They have some control, some enforceable control, but not complete. All right, so looks like we're going to be here a while. Get myself comfortable here. And get down to it. So, an independent contractor is hired by an employer to perform a specific task. Employer has no control over methods used by the independent contractor, which we stated. Examples of independent contractors are lawyers, physicians, and accountants. This is going to be our pile of pages for now. I basically set up some of my books over here so that I can make sure I see them, and they are different areas, various areas of study that I want to discuss in this channel that I think are important or useful to being a overall well-rounded person, a high-functioning member of society. Knowledge is power. All right, back to employment law. Economic realities test. Behavior control, financial control, if the relationship is permanent. A good example is the Mary Kay Cosmetics case. Elements of an employment contract. Generally, employment contracts are not required to be in writing because they are indefinite in nature. Next section, duties of employees, independent contractors are: number one, duty of loyalty. Relationship between employer and employee / independent contractor is fiduciary, based on trust and confidence. An employee has a duty to inform, obey instructions, and to protect confidential information. An employee or an independent contractor has a duty to disclose all pertinent information they learn of that will affect the employer, the business, or task at hand. So basically, while you're under somebody's employee, either as an independent contractor or as an employee, in layman's terms, you're expected to act in the best interest of the company. You have a duty of loyalty. The next is a duty to act in good faith. An employee / independent contractor has an obligation to perform all duties in good faith. They must also carry out tasks assigned by using reasonable skill and care. They have the duty to follow employer's instruction and not exceed authority delegated to them. All right? So, duty to act in good faith basically means they expect you to behave yourself while you're under their employ. You're supposed to be doing your work, using skill and care for the work you do, not haphazardly, and you're supposed to follow instructions and not go over what you've been allotted to do. The next is duty to account. For all compensation received, must not commingle funds, but keep employers' funds in a separate account from their own. So, if you're working with money, you can't commingle. Employee / independent contractor must not use the employer's funds for their own purposes. So, you think this goes without explaining, but stated, so we're going to talk about it. That's called stealing. You can't steal from your employer, and any employee that uses the employer's funds for their own personal gain is technically stealing. So, the chapter will go into the employment perspective. Okay? All right, the next section is employer duties, what the employer is expected to. The first one is duty to compensate employee / independent contractor for work performed. You are expected to pay people if you're an employer. Employees expect you to pay them. An employee, independent contractor, is entitled to an amount agreed upon in the contract, or they're entitled to a reasonable value of the services rendered. The employer has a responsibility to maintain safe working conditions. This gets closer. We'll probably touch on this later on in this section, talking about OSHA. Any tools or equipment furnished to the employee must be in proper working order. If an employee is injured during the scope of employment, they will be covered under workers' compensation. The scope of employment means the worker's on the job, basically. Okay. The next section is non-compete agreements. This is a contract where an employer provides employment or a severance package upon termination in return for employee's promise not to work for a competitor or open a competing business within the geographic area the employer transacts business in for a reasonable length of time. So basically they're paying you not to step on their toes, not to start up your own startup company that competes with them, or not go work with one of their competitors. All right. The next is a non-disclosure agreement. An employer's sale or use of trade secrets, confidential info, and or a work in progress that has commercial value or will result in harm. So you're expected not to tell the company secrets. You can be held liable in court if you leak the company's information. They usually have you sign at time of hiring non-disclosure agreements. Courts will enforce if used to protect the legitimate business interests. The next section is injunction. An injunction is an equitable remedy that prevents a party breaching a contract from rendering the same performance elsewhere. An injunction is the appropriate remedy to enforce a non-compete agreement. All right, so we look into the employment perspective. Contractual conditions. A condition that is contingent upon the occurrence of a future event. Tort liability. An employer is liable for any tort committed by their employee within the scope of employment. A tort is a private civil wrong as opposed to a crime, which is a wrong committed against the public. An employer is not liable for torts of independent contractors because the employer has no control over their work. Continue on with tort liability. An employer is liable for fraud, misrepresentation committed by an employee where they placed them in a position that led people to believe the agent employee had authority. So if one of your employees misrepresents themselves to the public, and you as their employer can get jammed up later on down the line if they are able to convince people that they have more authority than they do. Okay, so that's something to consider. Impersonation, basically. Some more employment perspectives. In summary, the key to a successful business is a positive relationship between employers and employees. Employers must convey in a clear and concise manner the employee's authority and duties. Employers must fairly compensate their workers. Employers should limit their liability by adequately educating and training their employees with regard to specific torts and breaches of contract. All right, that is conclusion for our first chapter of employment law. We will touch on chapter 2, which is selection, later on. I think we're going to make one more video, probably articulating some of the finer points in chapter 1, and just kind of discuss basically the summary and what we're hoping to gain out of this first chapter. Course outlines and objectives. All right.